Good afternoon and welcome to In Session. I'm Ryan Smith, and we begin with a huge development in the Casey Anthony murder case. The defense has filed a motion for the judge to remove himself. It's our trial tracker this afternoon. In Session correspondent Beth Karras has looked at the documents. Beth, I understand this has something to do with a blogger.
Yes, that's right. His name is Dave Neckel, and he goes by the name Marinade Dave online. And he's been blogging about the Casey Anthony case since November of 2008, so just months after she was arrested, a month after she was charged with the murder of her daughter, Kaylee. Now, he does blog about other cases, but he has posted a lot about this case, and he started attending court hearings. The first one he says he attended was last October, October 16, 2009. And that is the day when he says the judge initiated contact with him. After the hearing, the judge called him up to the bench. He had a deputy summon him from the public gallery. The judge apparently recognized his face because his image is posted on his blog. He says, and he told a defense investigator this last week, this is all in the motion that was filed last Friday, that the judge told him, I read your blog, I think it's the best one out there, you're very fair, you stick to the facts, etc. Months later, February of this year, when Marinade Dave Neckel, was in the hospital with a heart condition, he says the judge called him in mid-February just to wish him well and to make sure he was okay. So these are two different dates where the judge initiated contact with the blogger. Maybe that's not so bad, but the judge's statement to Dave Neckel that I think you're fair, you stick to the facts, is problematic, says the defense, because this blog had postings that predate the initial contact that included things like Casey must die, reference to a new member of the defense team, just another person to hate, and other, what the defense says, are pro-prosecution, anti-defense statements. Doesn't take a rocket scientist to reach that conclusion regarding some of the things he's posted. So, at a minimum, there could be this perception that the judge agrees with the things that Dave Neckel is posting, and that is a basis for the motion to recuse.
Wow. Now, Beth, when you talk about the statements that you're saying might be on there, Casey must die, these things, is that just a statement in a litany, a huge amount of statements made over time, or are there other things that have shown, that have been on this site, that would be examples that might get the judge in trouble?
Well, to be fair to Dave Neckel, these are really meaty blog posts. He does his homework. He talks about other cases. And he does talk about both sides. But there's no question that there are statements in there that are his opinion. He's entitled to his opinion. There's nothing wrong with that. But his opinion is that Casey Anthony is responsible for her daughter's death. And for the judge to say, I think you're fair, that's the problem. Does that mean the judge agrees with everything Neckel is saying? Now, Neckel was interviewed by a local reporter in Orlando last Friday morning before the motion was filed, and he said that the reporter was questioning him about the blog post. Neckel's won an award, by the way, for his blogging, and this is what Neckel said in part after that interview. He said that the focus of this interview began to lean toward my relationship with the judge. This was hours before the motion was filed, and I had no idea at the time that it was coming. My only message I have now is that Judge Stan Strickland stay the course. Cheney Mason is using a dirty stall tactic. Filthy is more like it. Cheney Mason, of course, is the newest member of the defense team. He is an Orlando attorney, very well respected, and he will be assisting Jose Baez in this case, and his name is all over these papers. Mason, by the way, notarized the document, and his notary commission expired last November, so they may have to refile this because of the defect in that.
Okay, well, it certainly seems like the judge is getting in some hot water possibly here. Hey, let me bring in our other panelists on this. We've got our in-session law enforcement contributor, Mike Brooks, right here with me. Mike Brooks, let's talk about this blogger. Does this affect in any way the investigation, how this proceeds in your mind when you look at the situation?
The investigation, no. But is he able to be, fair and impartial in making any of his rulings, and further rulings that come down on motions that come up? It just does not give a good perception, that he could be fair and impartial. Now, if he does recuse himself, what is this going to do to the schedule of this trial?
It's going to push it back.
Absolutely. Yeah. Now, another judge could take his place. But Judge Stan Strickland, he is the one who is most up to date. He knows he's been making all the rulings. And, they can go back and take a look. Were his rulings that he made, were they more towards the defense? Were they more towards the prosecution? I think so far it's been fair. But still, it doesn't look good for him to be communicating with this blogger.
It certainly doesn't look good. Let me also turn to in-session legal contributor Sunny Hostin. She's with us. She's right in New York. And also in Miami, we have got former Florida Circuit Judge David Young with us. But, Sunny, let me go to you first. Has this judge crossed the line? Because such a high-profile case, so much going on, and you're reaching out to a blogger to write in court to tell him, hey, I like your blog?
I have to say, I think that it is judicially inappropriate. The judge is supposed to be sort of the impartial person in that courtroom, and the judge has a lot of power because the judge does make rulings on what evidence gets in, all sorts of rulings. And when you have a judge reaching out, it has the very appearance of impropriety. If that judge remains after, on this case, after this motion has been filed, I would say, should she be found guilty, that could possibly also be fodder for an appeal. And so, I believe the standard in Florida is that the judge must rule immediately on it and must disqualify himself when his impartiality might reasonably be questioned. And I think if you use the reasonable person standard, all of us are thinking the same thing, I think, that it is unreasonable for this judge to have behaved in this way.
Right. And you know what, you talk about reasonably. Let me bring in former Judge David Young. David, talk to us. You're a Florida judge. You are familiar with these kinds of circumstances. David, when you look at this, let me ask you first, was this out of line? And then secondly, what really stands out here? Are all of these things problem? The initiation of contact, writing him the personal note to say, I hope you're okay in the hospital, or is it, or maybe, hey, is the prosecution, is the defense just reaching?
Well, I don't think the fact that he reached out to someone in the hospital would be grounds for recusal. But in Florida, you have to understand that the motions are deemed true. Now, the judge can't say anything. If the motion states something that is true, then the judge has to recuse himself. But if the certain requirements were not met, such as several statements were made back in 2008 and 2009, if it was known to the defense that those statements were made, in Florida, you only have 10 days in which to bring a recusal motion after learning about or hearing about some comments that a judge may have made.
And by the way, David, you're talking about a statement, I'm reading a document, you're talking about a statement made in July of 2008 at a bail hearing where the judge supposedly said the truth and Miss Anthony are strangers. You're saying that the defense now can't come back and say, hey, you've been talking to this blogger, and at the same time, we remember the statements you made before, and this is why you're biased.
That will be denied. The motion will be denied because it's factually insufficient to sustain a motion for recusal. The courts don't like to recuse themselves. It's an ego thing by the judges. Listen, we've all been there. But if the facts are what they are and the motion you have to be incorrect, then, the judge has to recuse himself. But in this case, the motion that I read, there's nothing that was known by the defense within the 10-day rule. So I think the motion is factually sufficient, and the judge legally should not recuse himself. Now, death is different. If Miss Anthony gets the death penalty, the attorney just said a few minutes ago, it could be another grounds for appeal. So if I was Judge Strickland, I probably would say, forget about my ego for a few minutes, grant the motion, and why cause the taxpayers of our state sufficient more dollars in trying a case potentially trying a case a second time.
But Judge Young,
you have great judges there that can handle the case.
Okay, so maybe it's on appeal, but Judge, do you look at this and say, where's the judgment here? I mean, to be honest with you, it's just, so maybe he doesn't recuse himself, but is this poor judgment just straight away from what you've seen?
Well, I would not have acted the way Judge Strickland had acted and reached out to bloggers and other members of the media. But however, he did, and it's all innocuous, and it does not fit within the four corners of the law, what the law is for recusal. Now, did he act stupid? He probably did act stupid. Saying that the blogger's been fair, well, why he said that gratuitous comment, I have no idea. But that's not enough to make you recuse yourself from a case. Okay,
and Sunny Hostin, let me turn to you. One last question here. We have this issue. This judge right now has got something in front of him to talk about the budget that the defense is going to get. Remember, Casey Anthony is an indigent here for purposes of the court, so the state's not going to pay legal fees, but they will be paying costs. Now this judge gets this motion. Do you think